All right, thank you all.
Thank you.
We're back. Thanks to Legislative IT here, and thanks for everybody's patience to pick up our work on H270. Attorney Childs is here with the latest and greatest draft. So, Michelle, could you walk us through draft 2 or 1.2? Excuse me.
Sure. So for the record, Michelle Childs, Office of Legislative Counsel, and as the chair mentioned, we're working off draft 2.1. And would you like me to just show you the changes from the last draft? I didn't know if you wanted to start to go through the section by section, or no, just do the changes.
Yeah, let's start with the changes and then we'll discuss anything that needs to discuss, and then we'll do a last jog through.
Sure. So if you'll turn to page 9, section 8 on the propagation cultivator license. So you'll see I have the highlighted language on line 15. So this is basically telling what someone who obtains a propagation license from the board can do. And this previous amount was 2,500 square feet, and that's been changed to 3,500 square feet of cannabis clones, immature plants, or mature plants. Next change is on page 13. And it's also section 13. And so we're moving on to the medical cannabis registry. And this is in the definition section for qualifying medical condition. So recall the bill as introduced had a list of a number of medical conditions that would then qualify someone to be able to make application for the registry. And all of them have been eliminated in this draft with the exception of PTSD. And you'll note that you'll see the struck language on line 16 through 18. Currently, PTSD is a recognized qualifying medical condition, but only if the applicant is undergoing psychotherapy or counseling with a licensed mental health provider. And so that requirement is taken out and it's just added back up to subdivision 8A. And then the final change, this is on the caregiver section with regard to the medical registry. And it's just a technical one. And that is if you'll see at the bottom of page 15 in subsection C, it talks about rulemaking, and there was if you look at the top of page 16, I intended to strike just his or her and kind of reword that a little bit because, as you know, we use gender neutral language as best we can. But I just need to restructure it and get in the words criminal history record on there because they are checking the Vermont conviction record as well as the registries. That's it.
Any questions about the changes? I can give a little bit of context and then I might ask Chair Pepper if he wants to weigh in. We had looked at, so we heard from, it was Satori, one of the multiple licensees in Middlebury, that they would like that cap to go from 2,500 to 3,500. I think the idea with the cap on the propagation, recall that this is like about the immature plants as starts, right? And when I asked Pepper about it earlier, it's one of those things of like it's a little bit arbitrary. I'm just trying to find some cap because there wasn't, especially in Ways and Means when this was previously came up about not just having infinite numbers of starts. So I thought we would take that recommendation. The board's not opposed to that. It would be a major change. Change on the criminal history record, that technical change reflects what Bryn had brought up for us earlier. So we made sure that we had struck all of, I think we were trying to get rid of gendered language in that one section in the caregiver section. And I think we were able in the qualifying medical condition in section 13 to capture the recommendations that we got in the email from the Human Services Committee chair. They had some concern after their drive through with the bill about enumerating more conditions without taking further testimony and doing some more research themselves. But I think they considered the post-traumatic stress disorder conversation previously, and we're comfortable with the Cannabis Control Board's recommendation around striking the need for 2 signatures. And we've heard some advocacy earlier from the patient perspective about asking us not to require that second signature. So, but we removed all of the other and newly enumerated conditions in this draft. So, other questions, thoughts folks had before we walk through? Yeah.
Thank you. So with the PTSD, is there still some requirement that be taken or provided with care with a physician, or is that completely not necessary anymore?
So Attorney Childs, I think all the enumerated conditions need a sign off or note to the effect that the person on the registry has one of the qualifying conditions.
Correct. And just as a little refresher is that all it is it's a medical verification form from your healthcare provider that you have one of those conditions. Mm-hmm. It's not, there's no kind of, the healthcare provider isn't agreeing to treat you with cannabis, or they're not prescribing cannabis or anything like that. They're just verifying that you meet the statutory definition and that you have that condition.
There's one follow-up. Oh, yeah. So they do have but they do have someone that they have care from, regularly or in some capacity.
They have to have an established patient healthcare provider relationship with that person. So it could be a physician, could be a physician's assistant, an RN, somebody that's listed under there that can sign that medical verification form, that knows you, that's done an examination, has a relationship with you, and has diagnosed you with that qualifying condition. And then they're just attesting to that. And then they're submitting that documentation to the board.
I should maybe know the answer to this, but I don't remember, I guess. But under the propagation cultivator's license, that's to test, transport, and sell cannabis plants only to the licensed cultivators, not out of state.
Right, you can't, everything's in state, still federally illegal, cannot be doing business with folks outside of Vermont. It's only with other licensed cannabis establishments.
And then my next question is, if for some reason, and it could happen, I guess, that they produce more of that product, whatever it might be, than what they can sell, what happens to the stuff that they can't sell?
I think that'd probably be a good question for Pepper in terms of what they do around compliance with their license, and how they might address an oversupply of a product and how long they can keep it, what they have to do because there's procedures that for destroying product, things like that, and how they have to handle it. And there's a whole chain of command that they have to follow in terms of record keeping. So I think you can probably address that.
Thanks.
Would it make sense to maybe get that question and any others answered from Pepper, and then we'll do a walkthrough, jog through the whole bill, Michelle, if that's okay?
Whatever you want.
Pepper, would you mind switching it up with Michelle and taking the hot seat for us? Get your feedback on these changes.
For the record, James Pepper, Chair of the Vermont Cannabis Control Board. And again, I'm happy to talk about these changes, any other changes. I know that there's probably going to be a final walkthrough, and I'm happy to just stick around for that as well. Yeah, I mean, very supportive of this bill in general. I think these changes actually do make the bill better. I mean, I know we had asked for additional qualifying conditions. That's a policy decision. If you don't want them, if the legislature doesn't want them, that's fine. The change to the propagation license is, again, just in line with keeping things small, keeping this local. You know, it was 2,500. That would have been a tier 2 out of 5 with respect to our other cultivator licenses. Now it's kind of in between a tier 2 and 3, but it's still small. And by the way, just to be clear, these are micro licenses compared to our neighbors in every other state. You know, I don't think, you know, our small cultivator, our tier 1 doesn't even register as like a craft cultivation in most of the states. I'm certainly supportive of the change, and was there anything else in the bill that you wanted to point me to?
There's that one technical change that Brandon asked us to make, that's at the top of page 16.
Yes. So I think, and honestly, I think that was just a mistake, and it was caught by Human Services Committee. You know, essentially, it said we're moving from a 50-state criminal background check to a Vermont background check, and then it authorized the board to make rules around what sort of convictions should be disqualifying, or what about, you know, what things from the registry should disqualify a person from being able to be a caregiver. And for some reason, that language around the criminal background check got struck as well. So essentially, we would have run a background check without any ability to kind of disqualify someone if we found a conviction that should be disqualifying. And so that is just unstriking what is current law, allowing us to use the results of the background check to disqualify someone. You know, we would come up with rules around it, what sort of convictions. You know, I would assume that it would be very similar with what we do with, you know, probably our other licensees, like anything that implicates some of these Cole memoranda issues around embezzlement, fraud, like felony embezzlement, felony fraud, you know, maybe felony gun convictions or domestic violence issues. You know, certain of the listed crimes, we just, you know, we don't allow them to get any kind of license in this district. So.
Any questions for Chair Pepper? Going once, going twice. I know you put a lot of work into the bill and trying to present us with some suggestions for how we can kind of do some early course corrections with the new retail market and also around some of the medical cannabis policy. So I appreciate the communication and your ability to be in here so much time, because I know you all are really busy as things emerge. So.
Well, I would say the same to everyone here. I know you all are very busy, and I know that, you know, not many people ran on a platform of fixing the cannabis market. Well, maybe some, but you know, this is a very rapidly evolving industry. Licensees in other states try and get ahead of the regulators. They try and find, you know, play in the joints of maybe areas that aren't as clear. And so we just need to continuously update this market and update the statutes that underlie them, so we can try our best to stay ahead of some of these issues. And there's actually a lot more coming your way, I imagine, around hemp-derived products and that are grown from legally, you know, federally legally grown hemp, but are psychoactive and intoxicating and are kind of exist in a gray area. There's more to come, unfortunately, or fortunately. And I'm happy to stay for the final walkthrough and come back in the chair before you guys take any action.
Well, thanks so much. So unless there are any other questions for Pepper from the committee, I'll invite Michelle back and we'll walk through the whole thing and make sure we understand what's in, what's out. If there's anything else we need to work on before we move this bill along. We good?
We're good. I just wasn't sure whether or not Pepper wanted to address Representative Higley's issue about what if somebody has too many plants, how do they address that?
Sure. And James Pepper, we have very strict inventory tracking requirements, and people have to update their inventory anytime any change happens to their inventory, or 2 weeks, or, you know, whichever comes first. And if, you know, with a propagation license, I think you may have a fear that, you know, once an immature plant becomes mature, all of a sudden you're a cultivator and you're not a propagator anymore. And so we would require destruction of that if that were to happen. And, you know, destroying cannabis plants, we have a process for that. It's laid out in regulation.
Thank you.
Okay. So I'm gonna just go section by section and I'll just keep moving along unless you stop me.
Yeah, we can do a jog because we've looked at
Right.
most of this a couple of
Okay.
times. And
So I'm-
if anybody in the committee wants us to stop and has a question about a piece, definitely just get your hand up. I'll try to keep scanning the room. Thanks.
Okay, so page 1, section 1, this is the repeal of the advisory committee. Page 3, section 2, this is repealing the sunset of the Cannabis Control Board. Remember, there was in the original bill in 2020, there was a sunset put out in the future for the board, and you're repealing that sunset. Section 3, looking at the bottom of the page, is just slightly tweaking the definition of advertisement. And I think you heard from Brent Hare about why they felt as though it would be more legally defensible to have this small language tweak. Page 4, bottom of the page, subdivision 8, just changing, making that small change, including propagation cultivators within the definition of cannabis establishment, so that they would, because you're adding a new licensee. Top of page 5, the new definition of a cannabis propagation cultivator. Section 4, there's a couple different changes in here. You'll see the first one being that in subdivision A3 on line 11. So right now, packages of cannabis products cannot contain more than 50 milligrams of THC. I think the chair did a great job explaining that earlier today about it's not a, there are limits on how much you can buy, but this is just talking about per packaging. So this isn't the overall amount. This is just how much you can have in each package. And that's being changed from 50 milligrams of THC to 100 milligrams of THC.
So this isn't in the bill, but since you brought it up, can you remind the committee what the total purchase cap is on THC?
It's an ounce, and there's a formula for how they figure that all out. If you're getting different types of
So
products.
it's the equivalent to an ounce of flour.
Right, because that's what you're allowed to possess under the legalization law that you passed prior to the establishment of the commercial system.
Thank you.
So next change is bottom of page 5 in subdivision 5, and this is concerning retailers, and we talked about that this morning. This was a small tweak that DOH asked the CCB for around annual inspections for retailers. Page 6, subdivision 8, you'll see the requirements for the rules for the new propagator licenses. Bottom of page 6, section 5 starts, and this is the section that currently, you see the language that's struck at the top of page 7 is the language around public records, access to records. That struck in favor of the addition of the new language in section 6 on the bottom of page 7. And that continues on through page 8.
One question that we did have come up earlier this morning on section 6 with the public records was whether this language is similar to public records protections for other similarly regulated industries.
I wouldn't know that. This is the only industry that I have any involvement in. Usually I'm all family law and occasional crimes, which is how I wound up here.
I think we will be
Occasional friends.
occasional crimes. I think what we'll be doing later on, as we get into some bills that deal more with the Public Records Act, is looking at more of this. It strikes me that this is similar to other Public Records Act exemptions that we've seen in past biennial with different, where we're striking a balance between what does the public reasonably need to know versus sort of trade secrets and protected intellectual property and that kind of thing. So, well, we can definitely kind of return to this thinking. Representative Nugent had that question before.
Right. And as you know, Tucker is our expert, our in-house expert on this. And anything there's having to do with public records and things like that, we always, all the attorneys in our office, we always run all of this stuff by him to make sure that it seems consistent and doesn't seem kind of way out there in comparison to what we have elsewhere in statute. Or at least he'll flag it for us if it is. So page 9, section 7, this is the tweak to the cultivator licenses. So just adding in that they can be purchasing and selling with a propagation cultivator. And then the new addition of the language on subdivision 3. Section 8 is your new propagation cultivator license. Page 10, section 9 is the tweak to the wholesaler license. Right now that they can only be doing business with certain other licensees, and this allows them to be doing business with any of the other licensees. That same kind of change is made in section 10 to the product manufacturers, and again in 11 with regard to the retail licenses. Page 11, bottom of the page, section 12, and this is on the fee schedule. So you see it starts out talking about manufacturers at the bottom there, and the talking about manufacturer tier 1, and the threshold there for this license is that they would be producing products. Right now it says not more than $10,000, and this ups it to not more than $50,000. Then on line 7, you have the new $500 fee for a propagation cultivator. Moving on to page 13, section 13, you have what we just talked about, the changes to the qualifying medical condition. Moving on to page 14, looking at line 18, section 954 on caregivers. We just talked about that, about the little technical tweak there. You also have in this section the change so that a caregiver can serve up to 2 patients at a time instead of just 1. Starting on line 9 for registration fees, this is a change so that if you have a qualifying medical condition of chronic pain, then you have to do the annual registration. But if you have kind of an intractable disease that is not going to be changing from year to year, so if you have MS, you don't have to necessarily go through and redo that every year and have your doctor fill out the same form saying, yes, they still have MS. Next page, on page 15. And this is the tweak to the caregiver background checks language. So instead of doing the national criminal history check, it's a name and date of birth Vermont criminal conviction check. Also checking the child protection registry as well as the vulnerable adult protection registry. Page 17, section 14 on the fees. So this is changing the fee for dispensaries, is that you'll see that currently there's a $20,000 registration fee for the first year of operation, and that's being decreased to $10,000. Section 15, and carries on over to page 18. Is just a clarification that this section doesn't apply to the retail sale of tobacco paraphernalia by a cannabis establishment. So if a cannabis establishment is selling a pipe or a bad or something like that, that tax that has been established for tobacco, for folks who have a tobacco license, then you don't have to get a tobacco license in order to sell a pipe if you're already licensed by the Cannabis Control Board to sell cannabis and cannabis products. Section 16, this is the establishment of the 3 new positions and the $850,000 appropriation. That was also in the BAA, which I understand went to the governor yesterday or the day before.
Yesterday.
Today, so.
Or to understand from the clerk's office. So my understanding, and maybe you would know this, or I can double check with the clerk, is I wanted to keep this in here just in case something happens with the BAA. Assuming that the BAA gets signed, we may look at a floor amendment, or the Appropriations Committee is going to look at this bill, obviously, and they could suggest an amendment. So I want to keep it in here for now, just in case something happens with the BAA in between now and a few days from now, and the deadline runs out. But for now, I want to make sure we're belt and suspenders on this lab appropriation.
Lots more stops for this bill and opportunities to take out that section. It's easy. And then final page is page 19, section 17. And this is just bumping out the date for when the auditor of accounts is to report to you on the structure of the Cannabis Control Board and whether that initial structure of setting it up with 3 members and as an independent executive board, executive branch entity still makes sense. And then the whole bill takes effect on July 1st of this year.
We've heard a lot about this bill. Any further questions about the bill? Questions about the words on the page? What's in it? Any of those technical pieces? Well, I want to open it up for committee discussion. Michelle, you can feel free to stick around, or if you want to get out of the hot seat, there may be a question or two that comes out of our committee discussion, but. Representative Waters-Evans.
You know, I've always got something to say. Thank you. So I have some questions about specifically removing those conditions like we were talking about earlier, and then Human Services heard yesterday. Do we have to do what they say?
No.
Oh, that's such a great
Such
question.
a layered.
No disrespect to them and their hard work, of course. But I just am wondering, because I'm new here, how that works. And I might disagree with their recommendation, which is why I'm asking.
So I obviously was the co-sponsor along with Representative Byron of the original version of this bill, and personally was comfortable with taking the recommendations from the Cannabis Control Board. I think there's a difference of opinion about the way that we approach the future of the medical program. And my guiding principle with this particular package, and I think we heard this from Chair Pepper several times along the way, was that this is the package that should be the kind of like the tweaks, things that are not, huge major policy changes. And so when the feedback that I was hearing from folks who were in the room in Human Services yesterday was that there was strong opposition to adding more enumerated conditions to the registry qualifications, qualifying medical conditions. And I want to continue to have a conversation about the health of and the future of our medical system. I want to make sure that patients have access to the types of products that they might not be able to get at the retail, adult use market. But really, there's a disagreement. And I think strategically for us and the other policy in this committee, the best thing to do right now is to say, hey, we hear you. You want to take some more testimony on these things before we make this policy change? Let's have that conversation another day. I'm kind of inclined to share your opinion that we should keep those in there and we should do that expansion. I don't know that now's the right time to do it. And so in asking Attorney Childs to do this latest draft, I said, take the recommendation for now of the Human Services Committee, but it's the committee's bill now. So I'm happy to have folks say, no, we should say, thanks for your work, but we want to keep those conditions in there. This is exactly the right time to have that conversation because we have kind of two versions of that section and we could go back, but I think we may hear on the floor a lot more pushback against our bill if we vote it out with those conditions in it.
And one of the, no, that was a very articulate way of laying that out, sort of like on how the bill will progress and whatnot. And one of the things I heard from members who I spoke to individually from the Human Services Committee was they just didn't have enough time to take testimony on it. And that's why the vote looked the way it did on the the straw poll, excuse me. So I want to be respectful of their desire to do a little bit more homework on it. So in my opinion, this conversation it's not over. We just remove this section now so they can continue to like dig in and mine in on the subject matter that's been going through their committee as this legalization of medical cannabis has evolved over the, how long, 15 years?
I think it was 2004.
Yeah, so
Adopted it.
almost 20. So I was not enthused with removing the language, but I also want to be respectful of our colleagues' desire to do their homework.
Okay.
No,
It just seems fairly arbitrary.
Yes.
Once again, I'm just saying that's what it seems to me, but I'm saying if we had, I guess maybe some context, and maybe Chair Pepper can offer this, or if maybe you guys would know. Why were those particular conditions included in the first place? And where did the information come from that led the creators of the bill or everybody who voted on it or wrote it? I guess I'm asking because if we have all this testimony or this information, not testimony, from Minnesota and those white papers and everything, if that's what led us to include those first conditions in the first iteration of it, why wouldn't that be sufficient evidence or reason or kind of a logical next step as far as this is concerned?
Based on the testimony, and my understanding is, and correct me if I'm wrong, but based on the testimony that they took yesterday, it was limited and did not provide them enough to like make an answer to say yes to this. They were cautious.
Sure, but why was like, for instance, Crohn's disease and ulcerative colitis are basically the same thing? I mean, not, but they're close. So why was Crohn's in that first one? Does anyone know?
I actually share your frustration.
Yeah, so Representative Hagley may be able to
I
provide some.
asked that question earlier, and I think, and Chair Pepper can correct me, but again, there appears to be in particular Minnesota that had studies done on
Yes.
these. And that rather than having our health department take an extensive time and effort to go through these, that's basically where they got those particular illnesses.
But like, so Crohn's is already included. It's part of the law right now.
So, yeah, so when you look at
But why was that included in the first place? That's the thing I don't understand.
So my understanding of the history of this.
Does anyone know?
Well, actually, so there's a combination of things, actually.
Okay.
The way this has been put together has been iterative over the almost 20 years that we've had, some version of the medical program in Vermont. And a lot of the pieces that are in there, my understanding of the history of it, because some of it predates my involvement in the legislature, has been about patient advocacy. Some of it's been about there being, some actual study or some medical professional being able to come in and say, yeah, there is evidence that this is helpful. The challenge that we have around the whole medical program and how we qualify people for it or not is that because cannabis has been a Schedule I drug at the federal level, there's not a ton of great data. Like we don't have federal, huge population level studies of what the benefit versus risks are of the therapeutic use of cannabis. So, I mean, I invite Chair Pepper if he wants to weigh in on this discussion, because it's really challenging for us as policymakers who are, we're all citizen legislators to go, which condition is in and which one's out and which doctor's opinion do we use on it. And so I'm sympathetic toward the testimony we heard earlier that we should base this more on, symptoms and a physician saying, this person has a condition, but I know that's not where some of our colleagues are, both inside and outside of this room. So I'm trying to find the way to thread the needle. So Chair Pepper, do you want to respond to that? And then I'll go to Representative Hango's question.
Sure, and it's James Pepper, Chair of the Cannabis Control Board. I mean, I would agree with everything that was said, and this program certainly predates my involvement with the legislature as well. And it has been it has evolved over time. I mean, I think it was very limited at first with terminal conditions. It's usually advocacy. I know PTSD, it was, a number of people coming in, witnesses with PTSD, saying that cannabis has really helped me. I think really the problem that we ran into is that, I don't think I did enough of my homework with the Health and Human Services Committee we have a very close working relationship with the Department of Health. And I think had they been able to weigh in yesterday, I think that the decision may have gone the other way, which, if they have the time to do this, I think I'll continue to kind of push for these and have, this bill has a long way to go, as Michelle said. There's still plenty of time left in this legislative session to kind of have these conversations with the Department of Health, with the Medical Society, and the other committees to and bring in the chair of the Minnesota board to kind of just say that just give the other committees some assurance that they did a lot of due diligence in order to come up with their list. And I think that's what was missing. And I think that's why, things didn't kind of go, they didn't support the cannabis board's recommendation.
I'll just say one more thing if that's okay.
Sure.
That's
why we're.
Yeah, but I don't want to, but it just on the same thing, it just seems like, especially in light of the testimony we heard earlier from, Jessie Lynn, was that her name? I can't remember her last name.
Jessie Lynn and Amelia.
Yeah, and I had asked the question because I have heard that a lot of times physicians will just, or healthcare providers will just lump everything, kind of throw it into the chronic pain category because that's something that they know will get you to get somebody that medical card that they need. But I don't think that's reflective of what actual needs are being met with the medical program. And I'll stop. Thank you.
I think you're making good points. And I don't want anybody on the committee to feel shy about saying,
I have never.
This is so you don't have to apologize for asking a question or speaking your mind. Representative Pango, thanks for being patient.
Sure, and nor have I.
That was a perfect handoff.
On the opposite end of that spectrum, this discussion that we're having here, and at the risk of sounding like I'm trying to debate what committee of jurisdiction this should be in, this whole medical conversation, in my opinion, should not be in this committee at all, because we are not the healthcare experts in this building. So on that note, I find this bill to be very expansive of a program that we obviously have not done our due diligence for. I mean, just hearing now, oh, we should have had more time, or we could have had more time, or we needed more time with the Department of Health. Those types of comments to me make me feel that this is not ready for prime time. So that is where I'm at with this. I find it really difficult to pass something that I know very little about and that we need more opinions on. Thank you.
Representative Murwicki and then Representative Hoover.
Thank you. Give a little history of the medical marijuana or cannabis for symptom control, as it was called when we first did it. I was on Human Services Committee when we passed that first bill. And it wasn't Healthcare Committee, it was Human Services. And as in any committee, we rely on the experts to come to us and we make the judgments. Some of the testimony that really convinced me that this was a good thing, for instance, we heard from a veteran of the Gulf War who was shot in the back and still had a bullet next to his spine. And the only thing he said that touched the pain was medical cannabis. He said he didn't get high on it, but it leveled the pain out so he could function. We heard from other people who were using it for epilepsy. And I don't remember extensive testimony to initiate this bill. So I just want to share that bit because I hear what you're saying about the healthcare committee, but I don't think that would be the committee of jurisdiction. It could be us, it could be human services, but whoever it is, I think we have to make the decisions after we get our testimony, and we've heard I think enough testimony for us to move forward on this. I think it's a challenge for us to make those decisions no matter what. And I'm ready to move forward with this. And I think this is the place for us to be. We've taken a lot of testimony here. I think I'm one of the people that wants to move cautiously on this, but I also think we're doing our due diligence to move slowly. And I think the Libra over here keeps balancing things out. And we've heard people say we're going too slow and others we're going too fast. And I think we're falling in the middle here. So I think I agree with that. We're coming to a good place.
I had Representative Hooper's question.
Oh, no, so no.
If Attorney Childs, if you had a.
No, I was just going to give you a little more context because Mike and I worked together on there, but if I can wait, there's no rush.
So Representative Hooper Burlington, you had your hand up next.
I'm going to change the subject. Child. You wanted to go on this.
Well, I was just gonna say, Pepper said it best. We're gonna keep updating this policy every session, so you'll get another shake.
And I did want to respond to Representative Hango and just say,
Oh, yes.
we right now we're yeah, oh yes. I really understand that this is tricky because there are folks who would prefer that we not have the state involved in a medical or an adult use retail cannabis market and on one side. And then now that we have both of those programs markets set up, there are folks who are saying, open them up, do a lot more. And we heard folks who were really urging us to go a lot farther and put many more things in this bill that would, expand access to use, that would expand the market, but would do many things that are not in this bill. And I think the fact that we've heard that no one is quite satisfied with what's in this bill means that we probably did do what Representative Rowe was saying and kind of thread the needle down the middle. A lot of us have been working on this cannabis policy for a number of years. It is really challenging. And I appreciate both sides of that perspective. And I've tried to walk a line in the middle and make sure we do hear from voices that don't agree with me, don't agree with positions on any side of the kind of spectrum of the debate. But these are really challenging questions, no doubt about it. Representative Hanko.
Thank you. I just want to make something really crystal clear. I am not opposed to the medical registry program at all. I just don't feel that we're the people to be legislating the medical side of it. Thank you.
Attorney Childs.
The time's probably passed, but I just wanted to, when you're talking about the history or had some questions, is that when the program was originally adopted, there had been a legislative study committee that recommended it, and then it took a couple of years for it to pass. And when it was originally adopted in 2004, the only conditions that were qualifying were cancer, HIV and AIDS, and MS. And you had to have been diagnosed with one of those conditions and have essentially exhausted all other treatments. So the medical provider had to say, oh, they've done this and they've done that, and they still have not gotten relief from that. And so it was quite restrictive at the beginning. And then over the years, it's just gradually changed a little bit. So, I've been here for 25 years and been doing these laws, all the drug laws since then. So every year I draft bills where somebody's saying, okay, how about Crohn's? There's, 17 states that allow Crohn's as a qualifying condition, and here's the studies for that, and then there's bills for that. And so it's just gradually been expanded over time and changed, slightly. But it has been very incremental over the last 20 years.
Okay, thanks.
Representative Hooper Brown.
For the record, this is the last time I was. Is there, following up on a comment that somebody made, is there a reason, either in license or tax statute, that an individual with a card could not go into a retail establishment and buy tax-free?
So there's a number of our retailers are actually saying, I will pay the tax for you. I think it's a legislative decision that has to be made.
I think it's what?
What's that?
You think it's what?
A legislative decision that would have to be made for a person with a medical card to get a tax waiver at an adult recreational store.
Card numbered?
The card is numbered, yes.
I can go into an auto parts store and buy one thing and pay a tax and buy another thing and not, based on a business. Just seems customer friendly to be able to allow people to use the outlet that they, or if it's closer and more convenient, blah, blah, blah.
So that's a policy, that's one of those big bucket of asks that was in the list from some advocates on different, from different stakeholders in this whole cannabis discussion that, I think deserves a conversation in the future. The idea that if you have a medical card that you maybe could use a adult use retail, having to go to a medical dispensary. But I think one of the reasons why we're not driving there right now is that we're concerned about the health of the medical dispensary system too, and making too many changes too fast with these two parallel places where you can get cannabis coexisting.
I would suppose the product offering is somewhat different.
It is, and in fact, one of the things that we did in our rules is said if you are a medical dispensary that wants to play in both the adult use and the medical, that you need to maintain a minimum 3-month supply for all of your patients, so that the patients really are held harmless. Because there are products that are available on the medical side that just either because of there's no profit, there's no market for them on the adult, like very high CBD, very low THC products, or things that have certain cannabinoids in them that just people don't want on the adult use side, but are very therapeutic for people with PTSD or something along those lines. And there's obviously high THC solid concentrates as well. So, we said if you're going to have both, and so far I think all but one of the companies is playing in both the adult use and the medical use. They're holding the patients harmless currently by maintaining those products that really, if you're a for-profit corporation, you might not stock, you wouldn't really have it on your adult use,
Well, there's something to talk about at some point.
Yeah, I don't think this will be the last time we think about the interplay between the two markets.
I don't think this subject is going to go away.
No, I think not. Representative Hickman.
Sure. I guess I'd first like to start off saying how much I appreciate Chair Pepper's efforts in keeping a lid on this program. It's I've seen him over the years and it over the years. I haven't supported the initiative in the past and won't be in regards to some of these changes. I know that the Cannabis Control Board has abilities to hold the line or hold, whether it's growers, retail, you name it, task, and they've done it with a light touch at first, and I can understand that. You know, it's a fledgling, I guess that's the word, right? Fledgling industry. But I hope that down the road for sure that they tighten up. Because again, I think the other states that I've heard and heard testimony from and so on, they're always pushing the envelope. The industry is always pushing the envelope. And you do have to keep ahead of it. And when I, again, read things from, you know, the Memorial Valley Health Group that's in constant discussions with law enforcement, and law enforcement says that the only thing that they can enforce is underage use and none of the other issues of public consumption and so on. You know, it sounds like there's a judicial system issue there as well, but again, coming back to whether it's Colorado, whether it's New York, with the illegal activities that are going on that aren't being stifled is a concern to me. And I you know, Representative Murwicki talked about an individual with pain that had helped. When this initially was considered, there was a young mom who came out from, I believe, Boulder, Colorado, on her own. And she told the horror stories of her son who got involved with dabbing and was in an institution in Texas. Her family couldn't go to a movie theater anymore in Boulder without, you know, the smell of marijuana. There was shootings down the street from her home in regards to the illicit market and the cartels that were still, if not as much, maybe more in the area. So those sorts of things really have a concern to me. And I've got to hand it to you now that you're doing as good a job as you can, but I think it's going to have to be stepped up a little bit on some of the enforcement ends.
Yeah, I take your point, and I would just say we recently publicized, because the case is now closed, the agreement has been signed, a very serious violation that we initiated. You know, someone, you know, we may be taking a kind of education first approach for unintentional actions. I mean, these are brand new regulations for everyone, you know, but there's certain things that people should know better. You know, there's certain things that just cross the line between unintentional mistake to kind of flagrant violations. And, you know, one was a person who crossed state lines, went down to New York and sold cannabis and posted the thing to Facebook or social media. And that person got a $20,000 fine and a 6-week suspension. And you know, we're balancing the needs of the people that we've asked to come in and to this market. They've never been subject to this level of regulation before, or any regulation before. There's a lot of people that are trying very hard to be compliant, and then there's people that are not. And you know, we're trying to take the education first approach with the former, and you know, we are cracking down on the latter, but you know, people are challenging the board, you know, they're challenging our advertising restrictions. They're trying to see how we respond, very much like raising a child, which, by the way, I have to go. I really apologize, but I have to go pick up my son from childcare at 3:30. I'm watching the clock tick down. They charge by the minute if they're not there at 3:30. So you know, I can call in if you'd like, but I really do need to.
I think we have pretty much wrapped our work up on this bill. So Chair Pepper, I really appreciate the time you've given us today. I know it was a really tough childcare day, and you know, the child care folks, I believe your wife's involved in advocacy around that. Is kind of case in point. So please go get your kids.
Thank you very much.
Thank you.
Thank you. Thank you for, again, you know, feel free to stop me in the halls or call me, or any questions that you have. I'm always, you know, close by.
Representative.
I think
No,
you can bring it up.
I'm trying to close the discussion.
Ditto to everything everyone was saying. Actually, I think that there's a lot of good points. I just wanted to share one perspective, which for me, I feel like we sort of talk about like, there's not enough evidence to show XYZ harms a lot of times. But then on the other hand, I don't see us holding that same standard for when we're saying something's like safe or okay for XYZ conditions as often. And so that's where I'm kind of concerned, because I think, from the government perspective, that's what I see as like my role, is to, I'm absolutely sure something is safe or something. I don't feel like I should say that. So I'm struggling on this bill because I don't think it's, I think there's some good things in there and a lot of hard work was done, but.
I guess I'd say that this bill still has some miles to go, and what we're always balancing out with any the controlled substances, and the reason this was in Gov.Ops, and that we now have the DLL, and so there's sort of a nexus here that's in this committee now with these controlled substances that the state is involved in regulating, and it's always this balance between, we know that there are these activities that are happening, that people consume alcohol, that people gamble, that people use cannabis recreationally. And the spectrum that where we all fall on the line of, should the state prohibit activity? Should it control and regulate that activity? Should it just allow people to do what they want to do and let the chips fall where they may? We're all going to fall on different places on that spectrum. And I think, Representative Nugent, your particular public health perspective is really valuable here. And it challenges me in my feeling of being a little bit more of like a harm reduction / libertarian person when it comes to some of these behaviors, is to say, what is our role? I mean, it's about the framing for this. Is it about, and then the question is, if our job here is to try to keep the public safe, I think having a reasonable, healthy retail market, I was convinced over the last few years of doing work on cannabis in this committee and outside of here with local questions about this stuff, that we would be better off having people have a well-regulated, well-functioning retail market that, had consumer protections. And this bill doesn't make any big, huge changes to that. There are some pretty significant tweaks to the policy. A new type of licensee, for instance, I think is not going to transform the market, but it's definitely a tweak. But I think that thing of how do we keep the public safe with this particular thing, I don't know if we can ever be, if we ever can get to the place where we're like absolutely sure. And so we try to be cautious as we do this, and we'll keep checking back in. All right, I think we beat this one. Yeah, Representative Hooper.
Mr. Chair, I'd like to make a motion to vote out of your most studious Government Operations Committee, page 270 in its latest version.
All right, so that'll be draft number 2.1 at the timestamp of 1:17 p.m. Representative Marwicki.
Wonder if we could see a clean copy of the bill.
Without the.
Without the highlights?
With that, well, there's a lot that's struck. Does that stay in the bill, the struck?
You said if you remove all the.
Okay.
Yeah, the only thing, so I just went out and there's 3 places that are highlighted, and those are the changes from the previous
Okay.
version.
Okay.
And I just took out the highlighting, and I'm gonna send a clean copy over to Andrea right now if you want to see it, but the only difference would be that I'm removing the yellow highlighting.
The highlights, right?
But the struck language, all of that is just,
Okay.
the repeal language.
Yeah, it's because we're repealing the board, so all that stuff is, yeah. It is a messy looking first section. I totally agree. I think we have to keep that in there in order to do the repeal, right, of the advisory Michelle, we would have to keep the,
Correct.
So too.
yes.
Yeah, I mean, there's other ways we can get around that, but you want people to be able to see what you're getting rid of. So,
Representative Rowicki, do you want to see a version without the highlights before we move it? Okay. All right. Any further discussion? All right, the clerk shall call roll.
Representative Byram,
Yes.
Representative Boyden, yes. Representative Pango,
No.
Representative Morgan,
No.
Representative Cooper of Burlington.
Yeah.
Representative Noricki.
Yeah.
Representative Chase,
Yes.
Representative Waters Evans,
Yes.
Representative Cooper of Randolph,
Yes.
Representative Nugent,
No.
Representative Higley,
No,
Representative McCarthy.
Yes. Thank you all. I will be reporting this bill. I think that thus wraps up our work on this bill. Really appreciate everybody's work on this. I know today especially was a lot of talking about cannabis policy. So we can hopefully put that aside and switch gears to other things. The last thing on the agenda today, and I think we've got to give Attorney Devlin a little time to get on some work in Senate Gov.Ops. So we're going to take a 15-minute break and then come back at 3:45 and hopefully do our little notaries bill. And that shouldn't take too long, I don't think, to pick that